Right, let's settle down, students. Welcome. Today's academic explainer is absolutely crucial. We are covering a guaranteed 16-mark question for your upcoming KSLU exams, Section 52, the Doctrine of Lis Pendens. Now, this is a foundational concept in property law, and honestly, the way you present this in your answer script, that's going to determine whether you scrape by with an average grade or secure a clear distinction. So we're going to approach this with absolute precision today. Before you even think about writing the substance of your answer in the exam hall, you must provide the synopsis we're about to see on the very first page. It gives the evaluator a rigid, high-scoring framework right off the bat.
So here's your synopsis. First, introduction and meaning. Second, essentials of Lis Pendens. Third, effect and illustrations. Fourth, landmark case laws. And finally, exceptions and conclusion.
All right, let's dive right into point number 1, introduction and meaning.
So you start your script with this major heading, Lis Pendens. It simply means pending litigation. It's embodied in Section 52 of the Transfer of Property Act, 1882, to maintain the status quo of property during litigation. Now, I'm reading this verbatim for a very good reason. You must reproduce this precisely. When you write this, you literally have to underline Section 52 of the Transfer of Property Act, 1882. Why? Because doing this immediately captures the evaluator's eye and locks in your initial marks. You see, the term lis means a suit or action, and pendens means pending. It's a fundamental legal maxim, right? Nothing new should be introduced while a litigation is actively pending.
Now pay very close attention to the strict statutory meaning here. During the pendency of a suit involving immovable property, no party can transfer or deal with the property to affect the other's rights. I am sternly warning you right now, do not try to be clever and summarize this. Never skip a single word of this statutory meaning. Don't write it in your own language. The law requires exactitude. If immovable property is the subject matter of a dispute, neither the plaintiff nor the defendant can just go ahead and alienate or transfer that property to a third party. Why? Because it would directly prejudice the opponent's rights once the final decree is actually passed.
So what's the actual object of this doctrine? Well, it prevents multiplicity of suits, it maintains status quo, and it protects the rights of parties during litigation. You have to write down these 3 distinct objectives in your answer script exactly as I just laid them out. In fact, I'm instructing you to use this exact bulleted format to squeeze out maximum marks in the middle section of your paper. Think about it practically. If a party were allowed to just sell off a disputed property during a trial, the winning party would have to file a brand new lawsuit against the new buyer. It would be an endless, vicious cycle of litigation. Nobody wants that. So, maintaining the status quo is absolutely the primary object here.
Moving on to our second main heading, Essentials of Lis Pendens.
You'll write this strictly in capital letters on your sheet. Essentials for application. 1. There must be a pending suit or proceeding. 2. The suit must be not collusive. 3. The suit must involve rights in immovable property. 4. The property must be directly and specifically in question. And 5. Transfer must affect rights of other party. Now, I read all 5 of those deliberately, and let me explicitly warn the entire class right now, if you miss even one of these essential points in your answer script, the KSLU evaluator will instantly deduct 3 marks. No questions asked. Also keep in mind, the suit cannot be some friendly fake setup. That's exactly what not collusive means. Plus, the property can't just be an incidental side issue in the case. It has to be the core, specific subject matter of the dispute. Memorize all 5 of these. Understood?
All right, let's open up the third heading, Effect and Illustrations.
Here is where we demonstrate practical application, the effect of doctrine. First, the transfer is not void. Second, it is subject to the result of the suit. And third, the transferee is bound by court decision. Listen to me very carefully on that first point. The transfer is not void. This is a massive trap for students year after year. When a property is sold during a pending suit, the sale itself isn't legally void or illegal from the absolute beginning. No. It is merely subject to the decree of the court. The transferee, meaning the buyer, basically steps right into the shoes of the seller, and they are absolutely bound by whatever final decision the judge makes, even if the poor buyer had no clue the lawsuit even existed.
Let's look at some examples. Illustration 1. A sues B for land ownership. B sells to C during the case. The sale is valid, but C is bound by the decision. Now, contrast that with illustration 2. A files a partition suit. A co-owner sells during the litigation. The buyer takes the property subject to the decree. In your examination hall, I want you to strictly draw a line straight down the middle of your paper. Compare an ownership suit on one side against a partition suit on the other, just like this. This kind of clear visual comparison proves to the evaluator, without a doubt, that you truly understand both absolute title disputes and shared ownership disputes under Section 52.
We also have some important principles to note here. The doctrine applies from the filing of the suit till the final decree. It includes appeals and execution proceedings, and crucially, it is based on public policy, not fraud. Make absolutely sure you write these down. And let me give you a pro tip for your exams. Writing down that exact phrase, based on public policy, not fraud, that demonstrates a deep master-level understanding of the syllabus to the examiner. You see, a lot of laymen assume lis pendens just exists to punish fraudulent sellers. It doesn't. It's strictly a matter of public policy and sheer necessity, ensuring that the court's valuable time isn't completely wasted and its decrees aren't made useless by people constantly selling off the assets.
Now we arrive at Section 4, Landmark Case Laws.
This is it. This is the absolute most vital section for your 16-mark answer. This is where you separate yourselves from the average students. Bellamy versus Sabine, established doctrine to prevent defeating court jurisdiction. Now, do not just name-drop the case and move on. You must write this case law in a separate boxed format to immediately capture the evaluator's attention. And here is the mandatory breakdown you need to provide. The brief background of this English case involves a gentleman, Mr. Bellamy, who instituted a suit against Mr. Sabine regarding a specific property. But while this equitable suit was pending, the property was sold to a third party. The final ratio decedent delivered by Lord Cranworth established that lis pendens is not founded upon the equitable doctrine of notice. No, it is founded upon the sheer necessity that a court's jurisdiction simply cannot be defeated by private alienations. Think about it. Ask yourselves this. If people could just sell off properties mid-lawsuit, wouldn't the court's judgment basically just be a piece of paper? Utterly unenforceable? Exactly. So the absolute relevance of this case is that it forms the very foundation of our Section 52. You must explain this logic clearly in your paper.
Next, we have Jairam Mudaliar versus Aya Swamy, which clarified the scope and application of lis pendens. Underline this case name prominently in your script. This is a paramount judgment from the Supreme Court of India. Now, the facts of this case involved a highly complex partition suit among family members. While the partition proceedings were actively ongoing, certain properties were actually sold off to third-party purchasers through public auctions and private sales. The Supreme Court's verdict definitively held that these purchases were entirely subservient to the rights of the parties in the litigation. The court clarified that the doctrine doesn't just annul the conveyance entirely, but rather it renders it subservient to the rights of the parties in the suit. So, why does this matter for Indian law? Well, it proves that our courts will rigorously apply this rule to protect the sanctity of ongoing domestic litigation, even when we're dealing with involuntary transfers. Detail this thoroughly for those full 16 marks.
Finally, we reach our last heading, Point 5, Exceptions and Conclusion.
Having exhausted the substantive law and our judicial precedents, we will now conclude this model exam script. Let's look at the exceptions to the doctrine. First, transfers made with the permission of the court. And second, collusive suits, where the doctrine is not applicable. Make sure you read these exceptions carefully and include them. You must remind the examiner that a collusive suit entirely destroys the application of this doctrine. If the plaintiff and the defendant are just secretly working together, colluding, just to freeze a property's title and defraud some third-party creditor, the court will absolutely strip away the protection of Section 52. Furthermore, if a party formally applies to the judge and the court grants explicit permission to sell the property during the suit, well, then the doctrine of lis pendens will not apply.
And finally, your conclusion. It ensures litigation is not ineffective by transfer of property. It protects judicial authority and fairness. I am demanding that all of you law students memorize this exact paragraph, word for word. It acts as the absolute, perfect, concise closing to secure top marks. It neatly ties together that public policy requirement with the statutory text we began the lecture with. So structure your answer exactly as we have discussed today. Synopsis, meaning, essentials, effects, deeply explained case laws, and this exact conclusion. But before you pack up your bags, I want you to ask yourself this one final question. If Section 52 did not exist, would our civil courts be anything more than toothless debating societies, completely powerless to enforce their own decrees? Ponder that as you prepare. Study diligently, follow the structure, and you will secure your 16 marks. Class dismissed.